YouTube, it's Tone back with another one for you. And so this one here is a continuation of the revocable trust PDF that we're going over. Uh it's a little bit different than the private trust that we set up, mind you, right? So I got that book coming out in about a week, and it's going to teach you how to do everything from A to Z, how to set up your security agreement trust, how to register it with the U.S. Treasury, how to fund it with bonds, and then how to create instruments to use for set off so you can discharge all your existing debts that you have and things like that. And obviously, when you become the secured party, it makes it way easier to discharge all of your secured debt, meaning anything that has a lien on it with property in question. It allows you to issue debt instruments against that debt in order to cancel that out. But that's a private trust we're talking about this here. This will be your public trust. So we're going over. We already went over the steps on how to register it with the and how to give notice to different state agencies, which documents to use, like your ID, birth certificate, social security card, a copy of the first and last page of your declaration of trust, and where to file them accordingly. Right now, what we're going over is the rest of the actual document itself and the stipulations, the details associated with this particular document, and I'll give my little 2 cents as we go down. I already talked about some of the things up at the top of this document, which was the first page that we just went over in the last video, part one. And I was just saying that there's certain things in in this document, like using certain codes and statutes and different verbiage that I would stay away from. Because keep in mind that when you're making these contracts, you're essentially agreeing to be bound by the stipulations of this contract. So if you start including different copyrighted material that you'll find in a lot of these legal dictionaries and different law books and things like that, those are like that's all copywritten codes and statutes. It's not really for you to use or to take. So if you were going to use anything along those lines, what I would stick to is probably the verbiage of that particular code or statute and not necessarily the actual numbers associated with it, because that's going to be the copyrighted item, right? So that's how you keep it so you don't drag yourself into being bound by any of these public codes and statutes and things like that, because that's it kind of defeats the purpose of creating a trust if you're just going to drag yourself back into that jurisdiction. It's kind of retarded. So here we go. So we're moving on to the second page of the trust here, and the first one, moving down. So we got the settler grantor is a part and parcel of California. So this is making reference to the Constitution of California. So you can use the Constitution of your particular state. So if you're going to use this document to create your revocable trust, you probably want to use the Constitution for your particular state. You don't want to use like even though you could use the Constitution for whatever state that you, because keep in mind that you're creating your rules for your entity as you create this document. So you can use the Constitution from a different state. So I guess with that said, go ahead and pick the one that you like the best. The one that is in line with your particular morals and stuff like that. So the settler grantor is a part and parcel of California. This trust shall be originally domiciled in the jurisdiction of the California State Republic, USA non-domestic, and shall be interpreted and construed under the Declaration of Independence, 1776, the Articles of Confederation, 1777, the Constitution for the United States of America, and the Bill of Rights. Bill of Rights is huge. And over 225 years of American case law. So they're dragging the case law into all this too, which is basically common law. So when you ever hear people making reference to common law, they're talking about case law, which is basically cases that have already been ruled on, more than likely by the Supreme Court, which then trickles down to all the lower courts. And then most likely, if you ever come in contact with a case similar to anything that's already been ruled on, the courts will go ahead and make a ruling based on what the Supreme Court has already ruled, right? So so common law is absolutely awesome, but it is essentially case law and man-made law. So, both United States of America Bill of Rights and over 225 years of American case law common law both prior to and after the undeclared federal corporate United States government bankruptcies of 1930 to 1938, and international law and treaties. Settler grantor hereby invokes any protections, benefits, and rights in any of these international agreements and treaties for, two, concerning or between Americans, the people of the North and South, Central America, applicable, and all of that. All right. Now, just keep in mind that you're taking benefits. All right. So, these are things that you probably want to stay away from, including in your document. Not that it really matters, because essentially what you're doing, and so the reason why I say that is because I'm actually comparing it to a private trust that we create, which includes, none of the benefits or anything like that. This is totally different. But just, you want to stay away from taking any benefits and things like that, because then you're subjecting yourself again to the rule of the commercial system. But at the same time, you're creating this for commercial purposes. So, that might not be that bad, but to stay away from taking any benefits and including that word in any of your documents, uh, and any international agreements. So, number one, all rights to obtain, use, request, or refuse, or authorize the administration of any food, beverage, nourishment, or water, or any substance to be infused or injected into or affecting the body by any means whatsoever. Uh, Number two, all rights to request, refuse, or authorize the administration of any drug manipulation, material, process, procedure, ray, or wave which alters or might alter the present or future state of my body, mind, spirit, or will by any means, method, or process whatsoever. All rights to access and use utilities upon discharge of the same unit cost of the comparable units of the usage offered to most favored customers, including cable, electricity, garbage, gas, internet, satellite, sewage, telephone, water, internet, and all of the above methods of communications, energy transmission, and food of water distribution, reserving all rights or trade name copyrighted notice to all users above. All rights to barter, buy, sell, or trade ideas, products, services, intellectual properties, or work. All rights to create, invent, adopt, utilize, promulgate, or any system of any means of currency, money, medium of exchange, coinage, barter, economic exchange, bookkeeping, record keeping, and the like. All rights to use any free, rented, leased, purchased, adversely possessed, fixed, or mobile domicile as though it were a permanent domicile without any requirement to apply for or obtain any government license, permit, certificate, or permission of whatever kind whatsoever. All rights to manage, maneuver, direct, guide, navigate, or travel in any form of automobile, motorized conveyance whatsoever without any requirement to apply for any obtain any government license, permit, certificate, or permission of any kind whatsoever. All rights to enter into obligations and procreate offspring, and to rear, educate, train, guide, spiritually enlighten any offspring without any requirement to apply for or obtain any government license, permit, certificate, or permission whatsoever. Uh, or my offspring will not be subject to agencies of the United States or United States of America. All rights to buy, sell, trade, grow, plant, cultivate, harvest, raise, gather, hunt, trap, angle, and store food, fiber, plant, herbs, cannabis, sativa, and raw materials for food, shelter, clothing, consumption, spiritual enlightenment, medicine, and survival. And keep in mind that it is essential to be this detailed and elaborate when you're creating your contracts, because law is created by contract. So this is what you're agreeing to be contracted in. And believe it or not, you do need to be this fucking detailed, because if you don't, then you're leaving way too much room open for speculation, which can lead to a misunderstanding. And then you may have to have a mediator involved at some point, which would mean that you would have to go to court to have an arbitrator or the judge rule if there's a disagreement between parties. Now, when you have contracts that are so detailed and elaborate, this kind of cuts all that shit right out before it could even start, because you went into such detail. So if you're wondering why it's so detailed, that is why. Because these people have fucking amazing imaginations, and if you leave anything open for interpretation or anything open, leave it open to the freaking imagination, it will be. Imagine that. So, All rights to buy, all right, all rights to exercise freedom of religion, worship, use of sacraments, spiritual practice, expression, status, nationality, and birthright without any burden on religious practices or the like, abridgment of free speech and the right to publish or the right to peaceably assemble or the right to petition governments for redress of grievances or correction of the like and for the public and private record. And all rights to keep and bear arms, right? And this is a big one too, man, because I don't know what people get off trying to tell you what you can and can't have on your person if you're not threatening anybody or anything like that. I mean, really, it's nobody's business what you have on you or what you do. It's when whatever you do, think, or say, or feel starts to interfere with somebody else's rights, which is their right to be free and pursue happiness and all that. Well then that becomes an issue. You know what I mean? Uh, and even if it comes down to how people feel about what you have on you and shit like that, that doesn't give anybody any rights to fucking invade your privacy and shit like that because somebody feels a certain way about what it is that you do or how you look or what you say. You know what I mean? It's not illegal to just fucking exist and then have somebody feel a certain way and then have them get the law involved. If there's no laws broken, meaning that if there is no injured party, then there is no law broken. You know what I mean? So all rights to keep and bear arms, concealed or unconcealed, for the self-defense of family and parties in treating physical protection of person or property. All rights to create, preserve, and maintain inviolable spiritual sanctuary and receive into same any and all parties requesting safety and shelter. All rights to create documents of travel of every kind whatsoever, including those signifying diplomatic status and immunity as a free, independent, and sovereign, uh, in fact. Uh, all claims of ownership or original and certificates of title to the corporal and incorporeal hereditaments, hereditary succession, and all innate aspects of being, mind, body, soul, free will, free choice, faculties of self. All right. So 15, all rights to privacy and security in person and property, including but not limited to all rights, safety, and security of all household or sanctuary dwellers or guests, and all papers and effects belonging to Jane Doe settler, trustee, assigner, co-signer, bailer, grantor, beneficiary, or any household or sanctuary dwellers or guests against governmental, quasi-governmental, or private intrusion, detained, entry, seizure, search, surveillance, trespass, assault, summons, or warrant, except with proof of superior claim duly filed in the commercial registry by any such intruding party in the private capacity of such intruding party, notwithstanding whatever purported authority, warrant, order, law, or color of law may be promulgated as the authority for any such intrusion, detainer, entry, seizure, search, surveillance, trespass, assault, summons, or warrant. All right. So this is opting out of their whole commercial system and end up the way that it does operate, which essentially translates into the legal system pretty easily because it is that. And so the legal system essentially is a commercial system, and it was and is designed to regulate commerce. That is as far as their jurisdiction goes. And that's why you'll find, in any of these violations, or laws or codes and statutes that they claim are ever broken, they're usually using codes and statutes in order to press the charge, right? And then the charge is going to actually be in a commercial nature against the estate of Jane Doe or John Doe or whoever it is in the all caps name. And so essentially that's going to be a charge against the estate of and not of the corporal body of or the physical vessel of. Those are two different things, right? And so essentially, when you're presented with a charge like that, what's actually happening is that they're drawing private credit from your estate, throwing it up in the air, and telling you that you have a criminal charge now. Essentially, what they need from you is an endorsement in order to be able to capitalize and cash in on the back end for that particular charge. Criminal charge is no different than a credit card charge, a light bill charge, anything like that. It's all the same. and so they can be dealt with in equity, or you can invoke law, which would be common law, and then go ahead and get the matter settled that way as well. So all right, so Article 2, trust property. Settler grantor hereby offers to convey via this revocable living trust on and for the record certain properties of de jure expressions, proof, credentials, certifications, authentication, documentation, affidavits, announcements, declarations, the nature, filings, correspondence, information, identifying marks, images, licenses, or travel documents, material, permits, registrations, and records numbers held by any entity, public or private, for any purpose, however acquired, as well as the analysis and use of any information and images contained therein, regardless of creator, method, location, process, or storage form, including all process algorithms, analyzing, classifying, comparing, compressing, displaying, identifying, processing, storing, and the transmitting said applications, filings, correspondence, information, identifying marks, image licenses, travel documents, materials, permits, registrations, and records numbers, and the like, an identity and description of the same which are presently known and or presented to both the settler, grantor, and trustee within each exchange, and which shall further be identified, described in Schedule A UCC financing statement, and or appropriate minutes thereafter, and shall be incorporated herein by reference and or attachment immediately upon its execution. Trust property is private property in all counties, states, and territories in the United States of America, all jurisdictional areas notwithstanding, any other country, continents, land, or territory, earth to be brought out by its fictitious zones secured by aboriginal or original allodial title records and treaty rights, all applicable. Jane Doe, as settler, has or will assign, convey, and deliver all of the rights, title, and interest in the property as described in Schedule A of this document as a gift without consideration to be held by the revocable living trust. So essentially, what's happening is that you're gifting all of these rights over to this particular trust. Okay. So, Article 3, Purposes of Trust. The settler grantor desires to create this trust to use as a conduit to express in the private and in the public, for whatever reason deemed necessary, his or her undisputed free national standards, status, nationality, birthrights, immunities, announcements, credentials, religion, and the like, applicable on and for the record for the benefit of the same, and to hold title to the trust property and to manage, protect, present, record, file, amend, and conserve it until death of the settler grantor, which would then be transferred to the heirs and assigned perpetually. This revocable living trust is created for the benefit of the beneficiaries to ensure they are well provided for after death. The settler grantor, however, during the lifetime of the settler grantor, the interest of the settler will be considered primary and superior of the interest of the beneficiaries. With this purpose, the primary assets management goal for the revocable living trust will be protection of the value of the property. The second asset management goal for the revocable living trust is to generate wealth growth at reasonable risk. All right. And so this is the biggest thing that you need to keep in mind too. All right. So when you're establishing this particular entity, which is binding you with another entity, uh, which when you do when you do when you create the private trust, essentially you're making the live living version of yourself and binding it with the estate of, which is the all capital letter name that was created by the state to represent you but isn't you. In this particular document here, you're gonna assign a another physical vessel the authority to be the trustee, which would make you the beneficiary. So if you ever came into any issues moving forward, you would have to get your trustee and hope that they know what they're doing in order to be able to settle any matters that may come about. So make sure that when you're picking a trustee, you pick somebody that you trust, because they can fucking rob you blind if you don't watch them. So make sure you find somebody that you can trust and somebody that is competent, or else you're going to be fucked. So Article 4, dispositive provisions. Whereas dispositive refers to something that settles a conflict or resolves a situation once and for all. The settler grantor may freely act under all or any of the powers by this agreement given to him, her, in all matters concerning the trust, after forming their judgment based upon all the circumstances of any particular situation, according to love, truth, peace, freedom, and justice, and to determine the best course to pursue the interest of the trust and the beneficiary without the necessity of obtaining consent or permission from any interested person or the consent of approval from any court. The managing director shall have the power to determine the allocation of receipts between corpus and income. This trust will have two beneficiaries for the life of its trust, and that those beneficiaries will be the same as settler grantor. Article 5. Trustee administrative powers, duties, and responsibilities. Whereas settler grants the trustees power to assume the roles and title of board of trustees, secured party trustee, executive director, and or administrator for the trust, and can and shall be carried out in accordance with the trust. The trustee shall be responsible for delegation of authority and execution in the daily business of the trust to include the right to execute and deliver all instruments of writings which may be advisable to carry out any of the foregoing powers on behalf of the beneficiaries. Only if the settler grantors is incapacitated, incarcerated, or in any capacity that prevents settler grantor from directing and handling said trust in accordance with to this trust indenture during the lifetime and unless until both become incapacitated, the primary trustee of this revocable trust shall be Jane Doe of the Flower County, California. In the event that the primary trustee passes away or becomes incapacitated, then the successor trustee shall be the surviving spouse and the surviving oldest born adopted child, common law, or other means of Jane Doe will serve as the acting trustee of this living trust. Trustee has all the authority provided by the California State of Republic, USA Non-Domestic Trust Code, with all rights retained therein. The trustee as a board shall hold all property of the assets in the trust in allodium in fee simple in the highest form of absolute free title ownership available in joint tenancy with the trust. Such properties and assets shall not be owned by the trustee in their own private character and capacity, but by them in the trust names as fiduciaries for the benefit of the trust and the capital unit holders. B. Trustees, executive trustees, and all successors of the trustee of the trust shall maintain independent trustee status at all times. The trustee shall be subject to the standards recognized in the law according to perform of the duties on obligations of the trust as provided by the common law for fiduciaries. No trustee, successor, or agent shall be liable for any facts or omissions of any other prior trustee or agents. No successor trustee shall be personally liable for any act of which the omission of any act required for him or her, his or his predecessor. With the approval of the board, a succeed trustees may accept the accounts rendered with the property and assets received as a full, complete discharge to the predecessor without incurring any liability for doing so. To compromise, settle, arbitrate, or defend any claim or demand in favor of or against the trust favor of the beneficiaries. uh, to incur and pay the ordinary and necessary expenses of administration, including but not by way of limitation, reasonable attorney fees, administration fees, notary fees, and the like. To initiate or defend at the expense of the offender any litigation for compensatory or punitive damages on behalf of the beneficiary, this assignment, or any property of the trust estate to act through an agent or attorney in fact by and under power of attorney duly executed by the settlor or the trustee in carrying out any of the authorities, powers, and duties. To appoint his/her successor trustee, if either of the named trustees shall die, resign, become incapacitated, or refuse to act further without having appointed a successor, the other named trustee may, but shall not be required to appoint a successor. The appointment of a successor shall be made by a duly acknowledged instrument delivery to the primary beneficiary and to the person, if any, then acting as trustee. Trust uh, specifically provides that a uh, trustees can delegate his power through a limited term of power of attorney. And so this is what happens a lot too. Like when you get letters from these agencies and things like that, and they start giving you offers, like freaking indictments and shit like that. What they're doing at this point is presenting you with an offer, and uh, if you agree to it, then you're gonna be subject to all of the fuckery that comes along with that particular offer to contract, right? So you can only get offers, and uh, and so I'm saying that because you see here that it's saying that if anybody else is appointed to be the trustee or fiduciary, that they need to be, duly noticed. And usually that's done through the administrative process, which would be either certified or registered mail or something like that, right? So to waive the payment of any compensation for their services, to interpret or construe the intent and direction of this trust indenture, to amend this indenture in accordance with the explicit instructions from the settler grantor. Article 6, trustee indemnity and hold harmless. So this is crucial too, right here. The hold harmless agreement. That shit is awesome. So Article 6, trustee indemnity and hold harmless, and which is basically limiting your liability or agreeing to have none. It's kind of like a LLC and shit like that. So that's one of the biggest things too to keep in mind is that when you're setting this up, you're setting up a business. You know what I mean? You're setting up an entity in order to be able to use as your monopoly piece in this whole game, and that's what allows you to go ahead and collect all of the credits that are being abandoned by everybody and left behind. And these banks are fucking scooping that all up, hoping that nobody realizes that they left all this shit on the table, right? So for all these debts that you're opening up and you go do mortgages, car notes, and things like that, you're leaving 10x the amount of whatever you financed out for the bank to just grab and do whatever they want with when you can go ahead and do that too. You know what I mean? So that's what this is stipulating right here. And this is what puts you in a position to be able to set up a trustee to be the fiduciary or the administrator of your accounts to be able to go ahead and scoop up all of that credit that everybody's leaving behind. And that's what this is really all about. All right. And so settler grantor instructs that the trust shall, without benefit of discussion and without division, does hereby expressly agree, covenant, and undertake the indemnification of, and does hold harmless trustees from against, but not limited to, any and all claims or legal actions, orders, warrants, judgments, demands, liabilities, losses, depositions, summons, lawsuits, costs, fines, liens, levies, penalties, damages, interest, and expenses whatsoever, both absolute and contingent, as are due and may hereafter arise, to include any such claims and the like that may hereafter arise with regard to any and all of the collateral of the trust, including but not limited to the trust property listed in Schedule A for collateral, applicable by separate documents presented herewith. The named trustee shall not be required to give any bond or other security. The trustee shall not be liable for any mistake or error of judgment in the administration of the trust, except for the willful misconduct, so long as they continue to exercise their duties and powers in a capacity primarily in the interest of the beneficiaries. Only if the settler grantor is incapacitated, incarcerated, or in any capacity that prevents the settlers from handling said trust in accordance to this trust indenture. The trustee will not be liable to this revocable living trust, the settler, or to the beneficiaries for any action or failure to act resulting in loss or harm to this revocable living trust, the settler, or the beneficiaries, except in this case gross negligence, willful misconduct, or reckless indifference to the purpose of the trust or the interest of the beneficiaries. A trustee will only be responsible for his or her acts, and no trustee will be liable for any act or actions occurring in this period before or after the tenure of the trustee. Any outstanding liabilities of a dead, resigning, or removed trustee are not discharged or affected by the trustee's death. Article 7, revocability. And revocability is essentially what it is. So you're able to revoke this trust at any point that you deem necessary, right? Uh, So this trust shall be revocable. However, the settler grantor expressly does not waive any rights, powers, privileges, whether alone or in conjunction with others, and regardless of when or from what source he may have acquired any such rights or power to alter, amend, invoke, ratify this trust or any of the terms, agreements in whole or in part the settler deem fit. At any time during the lifetime of the settler and while the settler is not incapacitated, the settler may, subject to the other provisions of this section, revoke this revocable living trust in its entirety on delivery to the acting trustee of a written instrument signed by the settlor. In the event that such revocation, in the event of such revocation, the remaining property will revert to the settlor after all the debts expenses attributable to the revocable trust have been paid. This revocable living trust may not be revoked after death of the settlor grantor. All right. So that basically is saying that at any point that you feel like firing these people or revoking the trust, um, in its entirety, that you can do so. So Article 8. This trust has been executed and delivered within the California State Republic, USA non-domestic, and shall be construed and administered according to the laws of the Declaration of Independence, the Articles of Confederation, 1777, the Constitution for the United States of America, and the Bill of Rights, 1791, and over a 225 years of American case law, common law, both prior to and under the undeclared federal corporate United States government bankruptcies of 1930 to 1938, and international laws and treaties. Uh, where we at? All right, so Article 9. Other provisions, comments, remarks, additions to the beneficiary. So, upon the death of the settlor grantor, the following individuals will comprise the beneficiaries of this living trust. A. The residuary beneficiary, all offsprings, heirs, assigns created through the body, fostered and or adopted by common law or other means of any Jane Doe. Any heir or issue of those beneficiaries the same as through the body fostered and or adopted by common law or other means that is entitled to a benefit under this revocable living trust in the place of any then deceased beneficiary. Amendment during grantor's lifetime. At any time during the lifetime of the settlor grantor, and while the settlor grantor is not incapacitated, the settlor grantor may subject to the other provisions of this trust, alter or amend this revocable living trust on delivery to the acting trustee of a written instrument signed by the settlor grantor. Amendments may include but are not limited to the following. The settlor grantor may change the number and identity of the settlor grantor, the trustee, successor trustees, or the beneficiaries. The settlor grantor may add or withdraw property from this revocable living trust. The revocable living trust may not be amended after the death of the settlor grantor. Distributions during the lifetime of the grantor. During the lifetime of the settlor, and while the settlor is not incapacitated, the acting trustee will distribute as much of the principal of the revocable living trust to the settlor as the settlor grantor may request. While the settlor is incapacitated and no longer able to manage or continue to manage their own affairs, then the acting trustee may withhold or make payments out of the resources of the revocable living trust of any amount that the acting trust, in their sole judgment, deem appropriate for the maintenance, comfort, and welfare of the settlor. So that's pretty self-explanatory right there. So distributions upon death of the grantor. Upon upon the death of the settlor grantor, and after resolving all applicable legal debts and obligations of the settlor grantor, the acting trustee will expeditiously act to distribute the remaining property as directed in this section. After resolving all applicable legal debts and obligations of the settlor, the acting trustee will distribute the remaining property in this revocable living trust in equal shares, individually and share and collectively the shares to the following beneficiaries. All offspring created through the body of fostered or adopted or by any common law other than the means of Jane Doe. Where a beneficiary is under the age of 18 at the time of his final distribution, and the beneficiary, not an adult dependent beneficiary, the acting trustee will then act as trustee by holding that share for the beneficiary under the same terms and conditions as outlined in this revocable living trust, and will keep that share invested, pay the income or capital as much of either or both of them acting as trustee in their sole discretion. Consider advisable for the maintenance, education, advancement, or benefit of the beneficiary until the beneficiary reaches the age of 18, whereupon then acting trustee will pay or transfer the rest and residue of that share to the beneficiary. Where a beneficiary is an adult dependent beneficiary at the time of the final distribution, and acting trustee may, at their sole discretion, continue to act as trustee by holding the share of any adult dependent beneficiary subject to the same terms and conditions contained in this revocable living trust, and to keep that share invested and pay the income capital as much or either both of them acting as trustees consider advisable for the maintenance, education, advancement, or benefit of that adult dependent beneficiary. Pay or transfer all capital assets and property of that share in the amount remaining of that share that the adult dependent beneficiary, subject to the same terms and conditions contained in this revocable living trust, uh, if any of the named beneficiaries do not survive the settlor grantor by at least 30 days, but do leave an heir, assign, or issue who survives the settlor grantor by at least 30 days, then the specific gift or share designated for that beneficiary or whatever kind of character and wherever located shall be distributed among those surviving heirs, assigns, or issue. Where those surviving heir assigns or issue are not of the age of 18, the acting trustee will hold the shares subject to the same terms and conditions contained in this revocable living trust. If any of the residual beneficiaries do not survive the grantor by at least 30 days and do not leave an heir, assign, or issue who survives the settlor, then the share designated for the beneficiary will revert to the residue of this revocable living trust. Keep in mind that, the trust is like a living entity in and of itself. You know what I mean? Also, so it can just be. You know what I mean? And this is what we do a lot of times when we leave our credit behind. It is a separate entity and somebody can go and grab it, And so this is what they do a lot of time with all of our credit. So if any of the residual beneficiaries do not survive, do not leave an heir for that beneficiary, the credit will revert to the residue of the revocable living trust. If all of the successor beneficiaries do not survive the settlor grantor by at least 30 days and do not leave an heir uh, or issue who survives, then all of the remaining property in the revocable living trust or whatever kind of character and wherever located will revert to the estate of the settlor grantor. If any of the real property to be distributed in the living trust remains subject to a mortgage time of the final distribution, then the beneficiary taking that mortgage property will take that property subject to the mortgage, and beneficiary will not be entitled to have mortgage paid out or resolved the remaining assets or the residue of the revocable living trust. So it's saying here that if you had any property that was in mortgage or was still getting paid for, that they'll just let them take the property and they're not able to draw the whatever credit is necessary to settle that debt from the trust. They would just take the house back. So if any of the personal property to be distributed in this revocable living trust is subject to any encumbrances or liens at the time of the final distribution, then the beneficiary taking that property will take that property subject to those encumbrances or liens, and the beneficiaries will not be entitled to have any encumbrance or lien paid out or resolved from the remaining assets or the residue of the living trust. All right, so then next uh we get into the trustee bonds and stuff like that. So these will be the promises that the trustee will have to make upon assigning them. So we still probably got like another hour to go too. I thought I was gonna bang this out faster. So, this is already 40 minutes that we got going on here. So I'm just gonna cut it here and we'll do the rest of the video and probably within this week we'll finish up the last video for this. But if you guys want this, if you guys want a free PDF of this, just send me an email. You already know I'm getting the rest of this book done by this week. I'm gonna really try to push it, you know what I mean, because I want to get this done. I'm trying to get, just all the information that I got, get it out in books and PDF formats, and then eventually just get all this shit down on videos and just go do something else for myself. But in the meantime, I'm gonna work on the rest of this video, which is probably gonna be another hour to read off the rest of this document. I didn't realize that it was so fucking elaborate, but it is, and this is a really good document as well too. So you already know. So that's what I got for you for now. Oh yeah, it is a game of chess. Stop playing checkers with these clowns. And that's what I got for you for now. Until we meet again.